Today's video will review 4 of the many new laws proposed during the 2022 session of the Utah State Legislature. First, HB 51, which deals with gestational agreements. The stated purpose of this bill is that it, quote, would amend the requirement that the intended parents be married for a gestational agreement and make technical and conforming changes, close quote. From what I can tell after reading House Bill 51, that means 1. Unmarried couples would no longer need to be married to enter into gestational agreements. Why? I don't know. How does this benefit society? I don't see how it does. And 2, she and her would no longer be used in reference to gestational mother. And so instead of she and her for the term gestational mother, it would now just be gestational mother only, which appears to be intended to make the term mother gender neutral. This seems at best like a solution in search of a non-existent problem, and at worst like social engineering, ignorant social engineering. Next, House Bill 84, which proposes to repeal the child support statute of limitations. Specifically, it would remove the 4-year limitation on enforcement of a child support order or a some certain judgment entered on or after May 4th, 2000? Not exactly sure why they picked that year. At first, this may seem to be, to some, a no-brainer, a good idea. You might say, I support HB 84 because it recognizes the public policy of supporting children and removes an obstacle for a parent who had to support the children during their minority from collecting child support based solely on the passage of time. I do not support HB 84 because statutes of limitation are good public policy. To quote Section 5 of American Jurisprudence 2nd, Legal Encyclopedia, quote, the statute of limitations doctrine serves the objectives of formality, certainty, and predictability. Defendants have a right to rely on the certainty the statute of limitations provides. Such statutes embody important public policy considerations in that they stimulate activity and punish negligence. Statutes of limitations serve to provide an adequate time for a diligent plaintiff to bring a cause of action, as well as to punish those parties who sit on their rights. Another object of statutes of limitation is to prevent surprise. The statutes of limitation are additionally intended to promote the efficient litigation of claims and further the policy that one must diligently pursue one's legal rights at the risk of losing them if they are not timely asserted. A statute of limitations is primarily intended to protect the sanctity of the outcome of litigation, not to prevent the burdens associated with participation in litigation. So Utah's current statute of limitation for enforcement of child support order is 4 years from the child's 18th birthday, or 8 years from the date of entry of a some certain judgment entered by a tribunal. The longer period of duration shall apply in every order. So that's up to 8 years if you have a judgment, and 4 years after the child turns 18? Look at 78B 5202. That's more than fair. I see no reason to get rid of the statute of limitations here. And then there is HB 86, proposing a new law for litigating over parenting plan modifications. This bill, if passed, would prohibit a court from granting a petition to modify a parenting plan until the parties have attended an educational course, yet another educational course. It would provide that a court may waive the educational course requirement for a petition to modify a parenting plan if course attendance and completion are not necessary, appropriate, feasible, or in the best interest of the parties, or and it would also create a mandatory educational course for parties when a petition to modify a parenting plan is filed. Want to know what this proposed educational course would entail? Well, if HB 86 is passed, it would mean, and I quote, a mandatory educational course designed to educate and sensitize parties about a child's needs during and after the modification of a parenting plan, including educating and instructing the parties on A, the definition of a parenting plan, as if they didn't already know that because they're seeking to modify it, so how they didn't know what they're seeking to modify they don't explain. B, the process for modifying a parenting plan. C, the objectives of a parenting plan. And D, how to effectively co-parent after separation or divorce. E, resources other than litigation that are available for resolving custody and child support issues, including alternative dispute resolution or mediation. F, how modification to a parenting plan may impact a child. G, how a parent may help the parent's child adjust to a modification of a parenting plan. And H, the signs and effects of high conflict and domestic violence issues on children and family relationships, close quote. We already have way too many laws governing divorce and family law in Utah. We don't need more, and frankly, we need fewer. We definitely do not need this law. Regardless, the last thing the divorced and unwed parents need is a law requiring them to attend yet another state-mandated, state-generated, so-called educational course. The courses we already require of parents aren't doing much, if any, good, and in fairness, while they're not doing any significant harm, Since when did "it doesn't hurt" become a compelling reason to pass a law? Laws like HB 86, if passed, insultingly treat parents like ignorant proles who must not be permitted to do anything without first being so-called educated by the government and paying a fee for it, mind you. People aren't that dumb, and in a free society, the state doesn't have that kind of paternalistic power. Last, HB 122, entitled Marriage Terminology Amendments. This bill seeks to substitute the word illegitimate with legally recognized, or not legally recognized, I should say. That would result in relationships currently identified as illegitimate as not legally recognized, which is the definition of illegitimate. Changing accurate terms because they have taken on a negative connotation is a no-win situation. Bastard became illegitimate, and now someone who wants to change illegitimate to not legally recognized thinks that's going to make that term not have a negative connotation later. Why use one word when three will do?